Welcome to the deep dive. Today we're getting into something pretty heavy in criminal law, the felony murder rule, FMR as it's called. Basically, it's this idea where if you're committing a serious crime, a felony, and someone dies, even accidentally,
Even completely unintendedly.
right, the intent you had for the felony can stand in for the malice you'd normally need to prove for murder. It's strict liability, pure and simple.
It is. And honestly, that strictness is what makes it so, well, controversial and legally interesting. The old common law version was incredibly broad,
Yeah.
leading to some really absurd outcomes.
Yeah, I read about those.
So the real story here isn't just the rule itself, but how courts have spent, decades trying to put guardrails on it to fight back against how harsh it can be.
Exactly. Trying to tame the beast, so to speak. So for this deep dive, we really need to unpack the four big ways courts limit this rule. Can you outline those for us?
Sure. We need to look at, first, what kinds of felonies actually count. They've narrowed that down. Second, the rules around causation, like who actually has to do the killing for the rule to apply.
Okay.
Third, there are limits on the time frame and location, the scope of the felony. When does the felony legally end? And finally, this concept called the merger doctrine, or independence. It stops certain felonies from being used at all.
Got it. Four key limitations. Let's tackle that first one right away. The type of felony. You mentioned the old rule was way too broad, like a bartender whose customer wanders off and freezes to death could be on the hook for murder.
Or, yeah, the classic example is someone filing a false tax return and the revenue agent chasing them slips, falls, and dies. Under the old rule, potentially murder. Clearly too much.
Clearly. So how did courts fix that? How did they limit which felonies trigger the rule?
They said the underlying felony has to be dangerous to life. That's the baseline.
Mm-hmm.
But here's the catch. Jurisdictions split on how to interpret dangerous to life.
Okay, how so?
Two main ways. One is the in fact dangerous approach. You look at the specific facts of the case, this particular crime, as it happened. Was it dangerous? Did it create a foreseeable risk?
All right, facts of the case. What's the other way?
The other, and often stricter way, is the inherently dangerous approach. Here, you ignore the specific facts. You look only at the crime's definition in the law, in the abstract. Is that type of crime inherently dangerous by its very nature?
Wow, okay. That's a huge difference. So under the abstract view, even if someone died in a really tragic, foreseeable way during a minor felony, if that type of felony isn't inherently dangerous on paper, then no felony murder.
Exactly. The unique facts don't matter for that threshold question.
Let's test that inherently dangerous standard. We need a case. How about People v. Phillips? Can you lay out the facts there? It's a really heartbreaking one.
It is. So the defendant was a doctor of chiropractic. He convinced the parents of an 8-year-old girl who had eye cancer to skip conventional surgery.
Which might have saved her life, or at least prolonged it.
Right. Instead, he pushed his own treatments, which were found to be fraudulent. Tragically, the little girl died. The prosecution charged felony murder based on the felony of grand theft, getting money from the parents through false pretenses about his treatment.
Okay, so the felony is grand theft. What was the core legal issue the court had to wrestle with?
The precise legal question was, can grand theft, specifically this act of medical fraud resulting in death, serve as the predicate felony for murder under the inherently dangerous in the abstract standard?
And what rule of law did the court apply? Can you state the rule and break down its elements for us?
Sure. The court applied the rule that the felony must be inherently dangerous, and that danger is determined only from the elements of the crime in the abstract without looking at the specific tragic facts of the case. So the test elements are basically, 1, is the felony inherently dangerous in the abstract, and 2, did the death result from committing that felony?
Thank you. Now for the court's elemental analysis. Let's go step by step. How did the court apply that first element, the inherently dangerous in the abstract part, to grand theft?
Well, the sub-issue was, is grand theft by its nature, just looking at the statute, a crime that poses a significant danger to human life?
Regardless of the medical context here.
Exactly. The court looked at the elements of grand theft, which essentially involve taking property unlawfully. It concluded that theft crimes, like grand theft or getting property by false pretenses, generally don't involve violence or physical danger. They're property crimes.
So even though this specific grand theft led to death,
the court said, looking at grand theft in the abstract, it's not inherently dangerous to life. Therefore, that first element of the test was not met.
I see. It's a very detached, legalistic way of looking at it, given the outcome.
It is. It's about the category of crime, not the specific act.
Understood. And after analyzing that element, what was the court's final conclusion in Phillips?
The court overturned the felony murder conviction. They explicitly stated that the inherently dangerous rule is meant to limit what they called a highly artificial concept, FMR, that deserves no extension. It was the court actively pushing back against the rule's breadth.
Okay, that really clarifies the inherently dangerous limitation. Now let's move to the second area, causation. This is where it gets really complex, I think. What happens if a dangerous felony is happening, but the person killed isn't shot by the felon, but maybe by the police, or the victim fighting back?
Right, this is a major point of division in the law. Who has to pull the trigger, essentially? There are two main theories.
Okay.
First is the agency theory. This is the majority view now. It says liability for felony murder is limited. It only applies if the killing is done by one of the felons or an accomplice, someone acting as an agent to the felony.
So if the cop shoots the bystander, the robber isn't liable for murder under this theory.
Correct. The second theory is the proximate cause theory. This is broader. It says the felon is liable if the death was a natural and probable consequence of the felony, even if a non-felon, like a police officer or victim, caused the death. The felony set the events in motion.
That's a huge difference in outcome. Agency versus proximate cause. Let's analyze a key case for the agency approach. Commonwealth v. Redline. What are the essential facts there?
Okay, red line. You had two individuals committing a robbery. During the commission or immediate flight, either a police officer or possibly the robbery victim shot and killed one of the robbers, the co-felon.
Wow. So the co-felon dies.
Yes, and the surviving robber was then charged with the felony murder of his own accomplice.
Charged with murdering his partner who was killed by the police, that feels counterintuitive. What was the core legal issue for the court?
The question was, can this surviving robber be held liable for felony murder when his co-felon was killed by a police officer, and that killing by the officer was arguably a justifiable homicide?
What rule did the Redline court use to sort this out? What are the elements?
The court strongly adopted the agency theory. It ruled that you can't base a murder conviction on a killing that was actually a justifiable homicide committed against one of the felons. The rule they applied effectively requires two things. One, the killing must be the act of the defendant or a co-felon. Two, the killing itself cannot be justifiable homicide if the person killed was participating in the felony.
Okay, let's do the elemental analysis. What about that first element? The killing must be the act of the defendant or a co-felon. How did that apply here?
Well, the facts show the fatal shot came from a police officer.
A non-felon.
Clearly a non-felon. The officer was acting against the felony, not in furtherance of it.
Yeah.
So under the agency theory, which requires the death to be caused by one of the criminal agents, this element was simply not met.
Because the killer wasn't part of the criminal enterprise.
Exactly.
So after finding that element wasn't met, what was the court's final conclusion in Redline?
The court concluded the surviving felon was not guilty of murdering his co-felon. And the policy behind this is pretty clear. Many courts feel it's unjust to hold someone responsible for the death of their willing partner in crime when that death is caused by lawful resistance to the crime.
That distinction between agency and proximate cause is critical then. Let's try a hypothetical to really nail down this causation idea, specifically the difference between a death that's a direct response versus one that's just a coincidence.
Okay, good idea.
Let's say someone, A, commits arson. They set fire to a warehouse to get insurance money. That's a dangerous felony. Scenario 1, a firefighter responding to the scene is killed fighting the blaze. Scenario 2, a completely unrelated person, a looter, sees the fire, goes into the burning building hoping to steal something, and dies from smoke inhalation. Is guilty of felony murder in both scenarios.
Okay, scenario 1, the firefighter. That death is almost certainly felony murder under either agency or proximate cause theory. Why? Because a firefighter responding to an arson is a direct, foreseeable response to the felonious act itself. It's a natural and probable consequence. The causal link is strong.
Makes sense. What about the looter in scenario 2?
The looter is different. Their death is generally seen as an abnormal intervening coincidence. The arson created a dangerous condition, yes, but the looter independently chose to enter that danger for their own criminal purpose. They weren't responding to the arson in the way a firefighter was. Their presence wasn't a foreseeable consequence of the arson itself in the same way. So typically, FMR would not apply to the looter's death.
That's a really clear distinction, response versus coincidence. Okay, let's move to the final major limitation. The merger doctrine, sometimes called the independence doctrine. What's the issue here? What if the felony used for FMR is basically the same act that caused the death, like, say, aggravated assault?
Right. The general rule here is that the underlying felony must be independent of the homicide. It can't be integral to it. It has to involve conduct separate from the acts of personal violence that caused the death.
Can you give examples?
Sure. Classic independent felonies are things like robbery, burglary, arson, rape, kidnapping. The purpose of the crime is different from just causing injury, but felonies like assault, aggravated battery, or even manslaughter directed at the person who dies are generally not considered independent. They merge with the homicide.
Why is that a problem? Why can't you use aggravated battery as the felony? If you batter someone and they happen to die, it seems like FMR territory.
But that leads to what courts call bootstrapping. Think about it. If any felonious assault that results in death could automatically become murder via FMR.
Then you wouldn't need the crime of manslaughter anymore, would you?
Exactly. It would effectively eliminate involuntary manslaughter for deaths caused by assault. Every time someone died from an unlawful beating, it would automatically be murder, regardless of whether the attacker actually intended to kill or showed extreme recklessness amounting to malice.
And prosecutors wouldn't have to prove malice aforethought, which is usually required for murder.
Precisely. It bypasses the normal requirements for murder. Courts almost universally reject this because, as some have said, it extends the FMR beyond any rational function that it is designed to serve. It would make the FMR swallow almost all homicides resulting from violence.
Okay, that makes perfect sense why merger is needed. We've covered a lot of ground for complex ways courts limit FMR. For someone listening, maybe studying for the bar or just trying to understand this, how do you pull this all together? Can you synthesize this into a kind of checklist for analyzing an FMR problem?
Absolutely. This is crucial for spotting the issues correctly. When you face a potential felony murder rule situation, you really need to run through this four-step diagnostic in this order.
Okay, step one.
Step one, the actor who did the killing. Was it a felon or a co-felon? This immediately brings up the agency versus proximate cause split. If it was a non-felon, you have to know if your jurisdiction follows the majority agency theory, usually no FMR liability for the felon, or the minority proximate cause theory. Felon might be liable. And remember the exception. If the felon uses the victim as a human shield, the felon is considered the actor.
Got it. Actor first. Step two.
Step two, the felony. Is the underlying felony dangerous enough? Here you have to figure out if the jurisdiction uses the strict, inherently dangerous in the abstract rule, like in Phillips where you only look at the statute, or the more fact-specific, dangerous in the facts of the case rule.
Check the type of felony and the standard used. Okay, step three.
Step three, the scope. Did the killing happen during the commission of the felony or during the immediate flight? This involves looking at time, place, and causal connection. A key issue here is flight. Has the felon reached a place of temporary safety? If so, the felony is considered over and FMR likely doesn't apply to subsequent deaths.
Time, place, causation, and escape.
Right.
Final step.
Step four, the independence merger. Is the underlying felony independent of the killing itself?
Yeah.
If the felony is something like aggravated assault or battery against the person who died, it will likely merge with the homicide, meaning FMR cannot be based on that felony.
Yeah.
You need a collateral independent felony like robbery or arson.
Actor, felony type, scope, independence, merger. That's a fantastic framework. This really shows the tension, doesn't it, between the harshness of the original strict liability rule and all these judicial efforts to inject some fairness and logic back into it.
It absolutely does. The FMR is constantly debated, modified, sometimes even abolished and then reinstated. But it hangs on, partly because it reflects a deep-seated idea. If you engage in inherently dangerous criminal activity, you bear the full responsibility for any deaths that result, intended or not.
So to wrap up, what's a final provocative thought you want to leave our listeners with on this topic?
Consider this. A number of states have significantly curtailed or even abolished FMR. Often arguing it forces prosecutors to prove actual malice, like extreme recklessness, under a depraved heart theory, which is harder. Does the fact that FMR still exists in many places suggest that maybe society finds the legal fiction of FMR a more palatable or perhaps just easier way to secure murder convictions in cases of accidental felony deaths compared to proving the felon's truly wicked state of mind? It's a fundamental policy question about justice, proof, and intent that's still very much alive.